Welcome to the Supreme Court of the United Kingdom, where today we're hearing the appeal in the case of the Queen on the application of A and the Secretary of State for the Home Department. The appeal is concerned with the lawfulness of guidance issued by the Home Secretary concerning the disclosure of previous convictions and other information relating to child sex offenders to members of the public. The case has been brought by a person who has convictions of that nature, and for that reason, the court has made an order granting anonymity to the claimant. The order is that no one shall publish or reveal his name or address, or publish or reveal any information which would be likely to lead to his identification or that of any member of his family in connection with these proceedings. I'm hearing this appeal with four colleagues whom I'll introduce now. First, Lord Lloyd Jones.
Morning.
Lord Briggs.
Good morning.
Lord Sales.
Good morning.
And Lord Burnett.
Good morning.
The submissions on behalf of the appellant are being presented by Mr. Hugh Southey, Queen's Counsel. So I'll hand over now to Mr. Southey and invite him to begin his submissions.
Thank you, my lords. I appear for the appellant in this matter with my learned friend, Mr. Bunting. My learned friends, Mr. Moffat, Queen's Counsel, and Mr. Knight appear for the Secretary of State for the Home Department. My lord, as my lord indicated, this is a challenge to the child sex offender disclosure scheme. I just make that point because there are some submissions made by my learned friend about what the nature of the challenge is. Certainly we submit it's clear that it is and has always been a challenge to the scheme. With that sort of preliminary remark behind me, what I'd like to do is just explain that the structure of my submissions is intended to be this. Firstly, I'll take the court through in some detail the policy, because that's obviously of some importance. I'll then look at the rights in issue and why we say they're significant. I'll then take the court to a number of authorities on the procedural rights that flow from the substantive rights that are in issue. I will then address the court about how the legality of policy should be assessed. And finally, I'll make some submissions about the legality of the policy in light of the earlier submissions I've made. So, adopting that structure, can I start by taking the court to the disclosure scheme? That is in the appendix part 2. It starts at page 218 within appendix part 2 or 359 electronically. And taking the court to a number of features or passages of that, the start of the scheme, essentially at page 218, records the background to the scheme, and in particular describes an evaluation of a pilot project that was undertaken by 4 police forces, and sets out the findings of those. And at this stage, probably the key finding, and one I'd highlight, is that it was said at bullet point 2, which is about 3/4 of the way down the page under key findings from evaluation. Police and offender managers interviewed perceived that the disclosure scheme formalised what they thought should be good practice in child protection. It was seen as providing greater clarity for staff by focusing on risk, focusing on the child, and permitting the sharing of information. And that's an important starting point in my submission. It's a theme that I'll come back to, because it demonstrates why schemes and policies like this are potentially so important. What policies like this in our submission are aimed to do is ensure essentially that decision makers have the relevant guidance, relevant good practice, all in one place, and it avoids essentially the need to reinvent the wheel each time. Now, the operation of the scheme is set out in some detail, but before looking at that detail, can I take you to paragraph 3.3, which is page 221 or electronic 362, which says this, underlined, which we understand is to emphasize its importance. One sees underlying and other highlighting features intended to emphasize importance, which is, it says this, that there is a need to follow all appropriate steps, essentially. It indicates there should be no disclosure without following the appropriate steps. And that's, again, an indication of the importance of the policy. The policy, I'll come on to this when looking at the case law regarding the approach to policy. This is a policy that prescribes a procedure to be followed. It means, essentially, particularly paragraph 3.3 means, that if a police force opts in, and I accept that there is no obligation on a police force to opt in, but if a police force opts into this guidance, then it's required to follow the procedure adopted. And that, in our submission, makes sense for a reason I'm going to come to, which is this is plainly intended to be a national scheme. And so one needs national standards. Now, the scheme is potentially quite significant from the point of view, well, it's potentially very significant from the point of view of the appellant. Firstly, if one goes back to 2.2, which is 2 pages earlier, 219, that makes the point that anyone can make an application about a person who has some form of contact with a child. That is significant in our submission because it means that this isn't like, for example, the criminal records check system where Parliament has identified a group as having a particular interest in disclosure. Disclosure is potentially to a wide range of people. Now, the way the procedure works is it has a number of stages. The first stage is that it starts at page 224, paragraph 5.1, and an individual can make contact essentially with the police. Now, that can happen anywhere essentially, and one sees, if one goes back to page 223, at the top of the page, one sees the potential for different police forces to be involved being identified, because there it's described how there can be a receiving force, a coordinating force, and a responding force. And the receiving force is where the application is made, the coordinating force is where the application resides, and the responding force is where the any other party lives. And so one can immediately see that at the very least there could be 3 police forces involved in this. If for some reason an applicant was to make an application outside their home area in relation to someone who lived in a 3rd area. Certainly the policy anticipates that that is possible. And that goes to the point.
Can I just mention, Mr. Southey, that if you're giving us page numbers, it's probably most helpful to have the electronic number.
Sorry.
I think we're all using those. Thank you.
Sorry, my lord. I will give you both. It's, yes, that 223 is page 364. If any, the reason I make that point is it goes back to the point I made before, which is in reality, this has to be a national scheme if it's going to be effective. And that's why it's not surprising the Secretary of State has taken the role of coordinating the scheme. going back to the first stage, as I say, is initial contact. And if one goes to page 226 or electronic 367, one sees there that there is provision for essentially urgent action. So there is the possibility that someone will walk into a police station and it will be clear that there is an immediate need for child protection action to be taken. And in reality, when we're looking at procedural safeguards, we are probably not realistically focused specifically on those urgent action cases. The second stage, essentially after that immediate contact, is described, and it again starts at the same page, further down the page, paragraph 5.2, is described as what's called the face-to-face application. And that is where effectively the applicant is seen and their application is gone through in some detail in the force and that it's gone through in some detail in a face-to-face meeting, and one sees that it's a face-to-face meeting at 5.2.2. 5.2.2 also makes the unsurprising point that one of the reasons why there needs to be a face-to-face meeting is to check that the application is genuine and is not malicious. And that's important because it demonstrates the sort of information, it's the first example of the sort of information that potentially needs to be obtained from someone who is the subject of an application, because clearly the subject of an application is likely to be in a good position to know or to make any points about whether or not the application is malicious. The next passage I need to draw attention to for the purposes of this argument is paragraph 5.2.9, which is on the next page, 227 electronic 368. And that describes, and that is an important passage in our submission, it describes how the applicant needs to be told that their inquiry will be dealt with confidentially. There are two, we submit, caveats essentially put or given or placed rather on the assurance of confidentiality. The first is in the second sentence of paragraph 5.29, and it's that confidentiality can only be guaranteed pending the outcome of the process. And so clearly an applicant is told that once the process is concluded with a decision, then there is a possibility that the confidentiality will be lifted. The second express caveat is in the following paragraph, which is where an individual is warned that if they disclose essentially evidence of an offence, their confidentiality may not be maintained. Going back though to 5.29, following on from the express caveat, there are two further sentences. One says that the police will need to consider whether representation should be sought. And the second is that once disclosure is made, the police will consider whether the subject should be informed. Now, that second sentence is obviously not inconsistent with the assurance of confidentiality, because it's dealing with the position after the application has been determined. The first sentence is the one that perhaps causes or gives rise to the greatest potential for confusion. What we submit about that first sentence is that there are a number of concerns about it. Firstly, it doesn't make clear that the need to consult may need to override confidentiality. In our submission, if one reads that passage as a whole, the implication would seem to be that representations can only be sought if they don't override confidentiality. Certainly that is a possible legitimate reading. It also would suggest that representations are unlikely to be sought in a large number of cases, because clearly if they are to be sought in a large number of cases, that would significantly undermine the assurances of confidentiality. Now, that interpretation is consistent perhaps with a couple of things. Firstly, if one goes to electronic 439 or page 298 within the appendix, one sees the last document in a privacy impact assessment. The privacy impact assessment starts, I haven't got the electronic page for that, it starts at page 282. I do the maths, I think that is 423, but the critical passage, the only passage I'm going to take the court to, is at 298. And that is the last page in what appears to be a sort of an assessment of the risks, privacy risks. And that significantly says two things. Firstly, the second, if one goes to box 6, how could risks associated with individuals being unaware of the collection be mitigated? That says, second sentence, at the point of disclosure, the subject and the parents of the child, of the children, will in the vast majority of the cases be aware the application. That is, as I say, said to be at the point of disclosure, not dealing with the prior position. But then that needs to be read with the last sentence, which says this: unless disclosure is made, there should be no reason for the fact that an application has been made to be disclosed to members of the public or the subject. Well, that suggests whoever wrote this understood that there was no real prospect of the individual being told of an application, making representations, and then persuading the police to change their mind. Because clearly, if representations were sought and the individual was then in a position to say, look, there are these reasons why disclosure shouldn't take place, there would be a significant risk, essentially, of the individual being aware of the application, even though no disclosure was being made. Final point I should make about the second stage is that the second stage involves information gathering, essentially. And if one goes back to page 250, page 391, electronically, one sees in particular the form that is completed at this stage. And that essentially sets out the information that should be gathered at this stage. And I draw attention to that because if one goes 2 pages forward, page 252, electronic 393, one sees details of the sorts of information that is potentially sought. Includes matters such as reason why the subject has contact with the children and the subject's current employment status. And I draw attention to those because, again, they are the sorts of things that a subject can potentially assist with. Going back to the guidance, if one goes to page 228 or electronic 369, the third stage essentially is described as empowerment education. Nothing arises in relation to that in this case. It's essentially about giving the applicant information. The next page, section 5.4, describes stage 4 as being a risk assessment. And the purpose of the risk assessment essentially is to decide whether or not there are concerns or no concerns. One sees that at 5.47. That is essentially, as I understand it, a sort of paper-based data gathering stage. And in the case of someone like the applicant, there's no doubt essentially about what the outcome of that stage would be, because if one goes to the start of stage 5, and paragraph 5.53, one sees that a case where there are concerns is one where there are convictions for child sex offences. The fifth stage is described as the decision route, concerns or no concerns. And at paragraph 5.54, which is page 230 or electronic 371, it said that if the application raises concerns, the police must consider if representation should be sought to ensure that all necessary information is available. Number of points I'd make about that. Firstly, there's no explanation of whether consultation at that stage or seeking of representations at that stage can override confidentiality. The language implies a discretion. The language doesn't recognise the importance of taking account of the importance of what's an issue from a subject's point of view. It also doesn't seek to identify the circumstances in which representations should or should not be sought. And I make that point because I'm going to take you to some guidance under the MAPPA scheme, which is strikingly different.
Can I just ask you, Mr. Sutty, you said that paragraph contains no explanation of whether representations at that stage can override confidentiality.
Yeah.
The confidentiality of what?
Well, sorry, what I was referring to then was the passage I'd started with, which talked about how an applicant was told that there would be confidentiality in relation to their application. And so it was the paragraph. Sorry, in fact it was just 4 pages back. It was paragraph 5.29, yeah. Where it was said that the applicant would be ensured their inquiry would be dealt with confidentially. Now, when read in context, that clearly it anticipates essentially that telling the subject that an application has been made is undermining that confidentiality, understandably, because clearly the subject is the person who is most likely to be interested in the fact of an application, and also may well be the person who is most likely to work out who's made the application, because they may know who is likely to have concerns about them having contact with children. And that's the confidentiality I was referring to. It goes back to the submission I made before, which is that passage creates a tension for decision makers because it doesn't make clear whether fairness overrides confidentiality, essentially. Lord.
Yes, I see.
Can I just say, I was going to take you to just to put that, what I've just said, and put that passage in context, to page 237, page 237, which is electronic 378. That is essentially a decision, what's described as a decision tree. It's the second part of a decision tree. The first part is the previous page. And it's from the point essentially at which the decision is reached as to whether there are concerns or no concerns. And one sees on that page, and indeed on the preceding page, no suggestion there that any consideration in the case where there are concerns needs to be given to consulting with the subject. That contrasts with the point about a quarter of the third of the page down, a third of the way down the page rather, where there is a box which is headed "Consider if subject should be informed of any disclosure." Obviously, a different concept to seeking representations, and so there's an express reference to the need to consider informing the individual, and that links to, if one goes to 264 or electronic 405, this is a document which is essentially what's described as a decision-making guide. It's a form for decision makers to fill in effectively to document their decision making. One sees that at the previous page, 263-404. And what one sees there, again, in the context clearly of sort of describing what the decision making process is, nothing there that says essentially consult or consider consulting or anything along those lines. And that contrasts with what one sees on page 265, electronic 406, where there is an express requirement to consider if the individual is to be informed of the disclosure. Going back to the policy, page 230, electronic 371, paragraph 5.6, starts the final stage essentially of the decision-making process, and it starts and it sets out that that's the process that essentially, or that's the stage at which either disclosure happens or non-disclosure happens. And that disclosure or non-disclosure occurs in a context, in this appellant's case at least, where in certain circumstances essentially there can be a presumption for disclosure. I say that because if one goes back, I'm sorry for taking you backwards and forwards, to page 219, page 360, electronic, paragraph 2.2. In the middle of that paragraph, there is a presumption that information will be disclosed if three matters are present. Firstly, convictions. Secondly, the individual will pose a risk. And thirdly, disclosure is necessary. And I draw attention to that because it's again another indication of why consultation may be so important. Because in particular, necessity may be something that the subject will be able to address. And if a subject is told, we are very concerned that you are having contact with this child, we are considering disclosure, one response of the subject may be to say, because the consequences of disclosure are so serious, I would rather move out of this area and end any contact I'm having with the child than have disclosure take place. And that's why necessity in our submission is something that a subject may well have something to discuss or something to address. Going back to the policy at page 231, electronic 372, notes that paragraph 5.6.13, decisions will normally be taken at a MAPA meeting. Draw attention to that, but our position is that the policies clearly anticipate that this is separate to the MAPA process. I'll come to that in a moment. Paragraph 5.6.15, Roman 3, makes it clear that there are human rights issues in this context, and makes it clear that risks are significant. Again, something the individual may wish to address. It refers to representations, but in our submission, it adds nothing to essentially the passages I've already drawn attention to. It again appears to imply that there is a discretion to seek representations. Going 2 pages further, 233, in the internal pagination, which is electronic 374, one sees at 5.6.25 recognition that an individual may not provide an undertaking regarding confidentiality. That's important when we come to the impact, and just draw attention to that so I don't come back to it. And it provides that there is a possibility that there will still be disclosure, albeit I recognise it recognises that should be less common. And then 5.6.27 deals with whether or not an individual should be informed of disclosure, and it indicates that one reason potentially for involving the individual in disclosure is it allows them to object and provide reasons. That, to some extent, suggests that one might have got to that stage without involving the offender. Now, the approach in our submission in the MAPA guidance, in this guidance, does contrast with the MAPA guidance, and the MAPA guidance is at electronic 502 or 361 in the hard copy. The relevant passage starts there. The MAPA guidance at paragraph 10.11 indicates essentially that there is a balancing exercise. More importantly, at 10.20, it deals with the
Sorry, could I have an electronic page number, please?
Sorry. 10.20 is electronic 503.362.
Thank you.
Sorry, my lord. 10.20 makes it clear, essentially, that the consideration must be given to seeking representations, but it goes beyond the scheme in question for 2 reasons. Firstly, it makes it clear that seeking representation should be the norm. In other words, we would submit recognizing there will be a presumption. And it then seeks to set out, unsurprisingly, a non-exclusive rather list, but it is an extensive list, a list of circumstances where that norm can be departed from. Finally, given what Mr. Justice Langstaff said in the Court of Appeal, it's important to note at paragraph 10.27, the scheme recognises, or the MAPA guidance rather recognises, that the sex offender disclosure scheme is, that's 364 electronic 505. Paragraph 10.27 recognises that the child sex offender disclosure scheme operates separately to the MAPA guidance, essentially. So the MAPA guidance, and the key critical difference essentially is that the sex offender disclosure scheme processes are initiated essentially by an application by a member of the public. As I say, that can be any member of the public.
Did the decision tree not indicate that if the subject is subject to MAPA arrangement, then the decision making will be it will take place under those arrangements?
It didn't. As we read, it doesn't say effectively. Well, depends what my lord means by that. In one sense, in the sense that
I don't have the tree. I can't remember what page it was at.
It's. I think. Well, I've got the hard copy. It's 291. I can probably get.
Try 378.
Yes, I think that may. Sorry, actually, I think I've got the wrong page. Yeah.
Yeah.
What it's describing there, and there is a relationship, and I drew attention to the relevant passage in the main policy. What it's describing there is that there is clearly a relationship with MAPA in the sense that MAPA, I mean, one of the major things that MAPA provides essentially is for there to be a MAPA body essentially, which brings together multi agencies, as the name says. And as we read the policy, what the policy is saying essentially is, if it's a MAPA case, the decision maker should be the MAPA body, but this policy operates separately to it. And there is a critical difference as well. And I made the point about how this process is initiated by a member of the public, and that does create a difference, because in the MAPA guidance, there's no issue, because it's essentially public authority led. There's no issue with confidentiality, and so there's no need to provide it, or there's no perceived need, perhaps is a better way of putting it, to provide assurances to the individual about confidentiality. When you apply, or when an individual applies under this scheme, it's started by the individual, and under the terms of the scheme, they are given the assurances about confidentiality. One final point I should make about that, my lord, we submit, and I'm going to come on to that in terms of policy, that the question is essentially whether there is a real risk for systemic reasons, essentially, that the policy will breach the rights of the individual. That means in our submission, one has to be alert to possible legitimate readings of this policy. It's not simply a question of deciding what is actually the policy. It's a question of looking at, given the drafting of the policy, what are potential readings of it? Because if it's a perfectly sensible and legitimate reading of the policy to read it in a particular way, that systemically gives rise to the possibility that it will be applied in that way.
Presumably, you'll come on to whether that's the correct approach to adopt.
Yes, I will, my lord. That's the sort of fourth stage of my argument. But I just wanted to put that down as a marker, because clearly there is a conceptual difference between the individual who comes along after a decision has been taken and says, my decision has not been treated in accordance with policy, in which case I accept that what one is looking for is the true legal meaning of the policy, and the situation where one's looking essentially in advance at the safeguards the policy provides, in which case one's looking at what are possible sensible readings of the policy, because it is the safeguard is undermined essentially, potentially, by a lack of clarity in the policy. Lord, can I then, and I'm going to deal with this very quickly, looking at time, because I want to get on to perhaps one of the most controversial areas, deal with the rights in issue. And there has been no dispute, essentially, that in this case, Article 8 is engaged. The Court of Appeal records that. But it's important, perhaps, to understand precisely the sorts of rights in issue, because obviously the more significant the rights, the greater the need for safeguards, essentially, about misuse. And we submit, and I won't take the court to it, because I'll come to it for another purpose, that the best or the most comprehensive analysis of the reasons why Article 8 is engaged in these sorts of circumstances is the judgment of the House of Lords in L, which is in core volume, or the primary authorities volume, tab 7, page 1032, and it's paragraph 24, Lord Hope, and he identifies essentially 3 reasons why.
Can we have an electronic page number again, please?
Sorry, 1032, my lord.
That is 1032. Thank you.
That's yes. If that's elect. I wasn't. I will. If I get this wrong, I'm sure I'll be corrected. But when I'm referring to page numbers, I'm not referring to the report page numbers from now on when I'm referring to law reports. And it's paragraph 24, and he identifies 3 reasons essentially why Article 8 is engaged when there is disclosure of sensitive information such as convictions. The first is an individual has a right to establish relationships, and plainly the sort of stigma associated with the sort of material in issue in this case undermines the ability to establish relationships. Secondly, he indicates that one has a right to a good name. And although someone in the applicant's position has previous convictions, the reality is that as time passes, they will increasingly become rehabilitated and people won't know about their previous offending. And that links to the third point, and that's this, which is that where essentially a conviction recedes into the past, it essentially becomes part of someone's private life, and the need for it to be public reduces. And in a case like that is particularly important, because there are good reasons for an individual to want to keep their past secret. The policy itself, again, I won't take you to it, it's electronic page 359, records that the pilot project identified concerns about negative reactions. That is a real problem in the context of a policy which permits anyone to make an application, potentially permits disclosure without the person signing an undertaking, potentially permits disclosure in circumstances going back to the policy itself, electronic 359. Again, the results of the pilot project recorded how applicants can find it difficult to keep information confidential, unsurprisingly given the child safety issues. And all of that can result in hostility. The applicant himself has described hostility he has faced when people have discovered his previous convictions. And that position can continue for life. There is no scheme that allows you to be exempted from this. And that's the case despite the fact that, for example, one can apply to be exempted from the sex offender registration scheme. And indeed, in F, again, I'll give you the reference. It's volume 3, tab 30, electronic 1874, paragraph 34. The Supreme Court recognised the importance of an individual being able to apply to be exempted as being highly relevant to proportionality. So all of that in our submission demonstrates that what is an issue from from the subject's point of view is a very significant interference with their rights. Now that explains in some senses the approach that has been adopted in relation to the third issue that I wanted to address, which is the right to procedural fairness. In our submission, in summary, both the common law and Article 8 have recognised the importance of an individual being able to make representations essentially before the sort of disclosure that is in issue in this case. If one looks first, this is in the primary authorities at tab 12, electronic 1206, at the authority of, if one looks at the judgment in ex parte Thorpe, also known as ex parte AB, which is essentially the first, certainly as far as we're aware, authority that looks at the common law right to disclosure of previous convictions and, perhaps more importantly, common law restrictions on that right to disclosure. In the context of the common law, this is obviously before the Human Rights Act by some time. The Court of Appeal, Lord Wolfe, page 428 of the report, say 1206 of the electronic, just below letter B, said this: disclosure should only be made where there's a pressing need for that disclosure. Before reaching their decision as to whether disclosure, whether to disclose, the police require as much information as can reasonably practically be obtained in the circumstances. In the majority of the situations which can be anticipated, it will be obvious that the subject of the possible disclosure will often be in the best position to provide information which will be valuable when assessing risk. As I say, that is essentially, certainly as far as we're aware, essentially the first judgment dealing with disclosure of previous convictions. It's recognising the importance of consulting with the individual, and it does so based essentially on on the basis of one matter, which features in a number of the judgments, which is the idea that the person who is the subject of disclosure will quite often be will quite often be in the best position to provide relevant information. And I've already touched upon that when looking at the policy, how there are a number of areas recognised in the policy where the subject of disclosure is likely to be in the best position to provide information. Now that in our submission it has been followed in a number of cases. I'm not going to go through all the cases. We've set them out at length in our statement of case, which is at core page 63, paragraph 3.10. What I would indicate, though, is that what I would submit is that what has subsequently happened is that the case law has also recognised essentially that this is an area where Article 8 potentially implies procedural rights. And indeed, my learned friend, in his statement of case at paragraph 91, which is core 106, accepts that there are procedural rights that flow from Article 8, and accepts in particular that the test is as set out in Blekic, which is at volume 5, tab 56, page 2799 electronically, paragraph 68. And that, in a statement of principle, which is in a case which was nothing to do with privacy rights, essentially. It was to do with rights to a home. Set out a general statement of principle, which, as I say, my learned friend fairly, and we would say correctly, accepts applied, which makes it clear that having regard to the circumstances of the case and the importance of the decisions to be taken, the reason why, albeit briefly, because of time, I touched on what was an issue in this case. That's the reason why I touched on those issues. The applicant has been involved in the decision-making process, seen as a whole, to a degree sufficient to provide them with the requisite protection of their interests. A couple of points I'd make about that statement of principle. Firstly, the reference to the importance of what's in issue, and indeed the reference to the protection of the individual's interests, in our submission reflects something that my Lord Reid will remember from the Osborne case, which is the fact that fairness isn't simply about ensuring that a decision is accurate or is reliable. In our submission, a decision fairness also needs to reflect the importance of what's in issue, and that in our submission is reflected in Blekic, and I'll come on to Osborne in a minute. Secondly, what that implies in our submission is that there does need to be some involvement by the individual. And that's striking because, as I say, on its face, the disclosure scheme doesn't require that. And that links, in one sense, to a point, and it's probably worth dealing with it now, that comes out of one of the key authorities in this area, an authority I'll come back to for other reasons, the Christian Institute case. If one goes to Primary Authorities, Volume 1, tab 2, page 822, electronic 822, in that case, I think it was Baroness Hale, Lord Reed, and Lord Hodge, with whom the other members of the court agreed, indicated firstly at paragraph 80 that T, authority that we'll come to in a moment because of in accordance with the law, that T indicated the importance of protection against arbitrary interference and how that required safeguards to enable proportionality to be examined. And then at paragraph 84, considered whether or not that was met, or that standard was met, essentially, in the context of a statutory scheme for, as I understand it, disclosure of information, which provided some limited statutory right to consultation with a child involved, but none. That didn't apply in all circumstances, and it didn't apply to parents. And then the guidance essentially provided for routine good practice. That was held to be not in accordance with the law, essentially because towards about 5 lines up from the end of paragraph 84, there was no objectively compelling reason for the failure to ascertain and have regard to their views. I draw attention to this essentially as an example of this court in our submission adopting the Blekic approach of saying essentially there needs to be involvement of those whose rights are in issue, if there's some good reason not to. That's essentially a presumption.
The central, the nub of it really is in the sentence beginning about 10 lines up from the end of a paragraph, that it was possible under the scheme that highly confidential information about, for example, a young person's use of contraceptives or pregnancy or a sexually transmitted disease could be disclosed to a wide range of public authorities. If a person went to their doctor, say a 16-year-old girl went to her doctor asking to prescribe contraceptives, then that information could be shared under the scheme with her headmaster at her school, without the child or anybody else in the family being told that the information was being disclosed. And without there being any, as I said, without there being any compelling reason for sharing the information without informing the child that this information was going to be shared.
My lord, so I'm not.
It's a very strong case on its facts.
I'm not disagreeing with. I wouldn't disagree with it being a very strong case on its facts. But I think, but I would submit there are 2 points really I'm making here. The first is that although I'm not saying necessarily one can draw a complete comparison, and each case there are different factors in each case, and it's sometimes difficult to weigh up the relative importance of each factor. But although I can see that the sort of information, particularly about a child, was particularly sensitive, ultimately, in our submission, the reason for that approach is it goes back to the Blekic principle, and the Blekic principle is clear about the importance of involving a decision, a person who is subject to an interference with their rights. And my point here is that fundamentally, the problem with the policy we've been looking at is it doesn't include a right essentially for the individual to be involved in the disclosure process. The second point I'd make is that although, as I say, I accept that the rights in issue were particularly important in the Christian Institute case, one shouldn't, and it goes back to the point I made, and I went through fairly quickly. One shouldn't underestimate the importance of what's in issue here, because the individual it is an individual who may have rebuilt their life, may have rebuilt a normal life. In the case of the applicant, hasn't been involved in offending for a very lengthy period of time, and is at risk, essentially, of having that life disrupted. And of course, one difference between this case and that case is that while in the Christian Institute case, one can see that the people who were potential recipients were a limited group, essentially, who might be said to have the best interests of the child at heart, or at least in principle should have that. Here, anyone can potentially get disclosure. And that can be potentially, the risk of misuse is potentially greater.
One has to bear in mind that the context here is the prevention of crime.
Yes.
And action by the police taken in accordance with their duty under common law to prevent the commission of crime.
Yes.
It's a trickier context in which to say that the person suspected of committing crime holds rights against the police.
Well, except it's one's looking. What one's looking at is the right ultimately to procedural fairness, and that there are a couple of reasons why we would submit that's particularly important in this context. One is that the decision making essentially in this context, partly because it's been prompted by a member of the public, may be based on inaccurate or incomplete information. And that's one of the reasons why it's particularly important to consult. The second reason is this, which is recognized in the material, and I was going to come to it. It chimes with the comments my lord made in his judgment in Osborne, which is that, as the government has recognized, if you have a system that is too draconian, essentially, it runs the risk of forcing people who pose a risk underground. And that's the concern that was expressed in relation, for example, to American-style systems of automatic disclosure. The concern that the UK government had was that would force the individual underground. And so that's another reason why it is potentially important.
But there's a sense in which you're pushing at an open door, because you've shown us you've shown us at least one passage in the guidance under this scheme where it said that, in effect, it said that the police will ordinarily speak to the subject as part of their investigation into whether or not disclosure is appropriate. And we also foreseen that as well in the under Mappa scheme. But naturally enough, it also says you don't need to do that if there's an imminent danger to the child and therefore a need for immediate action.
Well, except, my lord, that we would submit there, and this is why, in some sense, we spent some time on the map on the guidance and issue. We would submit that there's a critical difference between the MAPA guidance and the guidance in issue. The MAPA guidance says the norm is consultation. If, for example, there's an imminent risk, then you don't need to consult. The guidance in issue here says think about consulting, doesn't suggest that should necessarily be the norm, and says give an assurance to the individual that their application will be confidential until the point at which disclosure takes place. Well, consulting with the individual meaningfully is difficult if you've given an undertaking of confidentiality, because as soon as you consult about an application, you are revealing the fact of the application, which may reveal who the applicant is. It certainly reveals the fact of the application. And indeed, if the consultation is going to be meaningful, given the concerns about potentially malicious applications, for example, one is quite likely to need to be relatively clear about who the applicant is. May not necessarily mean naming the individual, but one might need to, for example, say, do you have any issue with your neighbours? And that's the critical point. That's why I don't accept, in one sense, I'm pushing it an open door, because the policy on a proper reading in our submission, or on certainly a reasonable reading, essentially indicates to decision makers they have more discretion than we would submit they do have.
So is really your complaint that although the guidance tells us, or tells the police, for example, in paragraph 5.5.4, that the police must consider if representation should be sought from the subject, you say it doesn't go on to say enough about the factors which should be taken into account in taking that decision?
Exactly. I mean, if it's the contrast in some senses between that guidance and the MAPA guidance, because the MAPA guidance starts with that same sort of you need to consider representations, but then says representations are the norm, and these are the sorts of circumstances where that norm can be departed from. In contrast, I mean, the only guidance really as to why you should be considering representations is essentially to say you might consider representations because you might think you want further information, essentially. And of course, that's one of the reasons why I've been emphasizing Osborne and why I've been emphasizing Bleckig. Both of those cases mean that one needs to take account of the importance of what's in issue. You know, if going back to the point I made about the recognized risks of offenders being chased underground, essentially, if you say to an individual, you may be subject to a process, essentially, which causes you that results in disclosure without you being involved, and with just because we think we've got enough information, that may be seen as unfair. It needs to reflect in our submission the importance of what's in. And in one sense, the problem for a decision maker also is you don't know. It's very difficult to know what you don't know. You don't know if the individual. How do you know if an application is malicious if you don't ask all parties, essentially? You know, the applicant is hardly likely to say, well, you know, I hate this person, we had a gambling debt or whatever, and I want to find out anything I can. Well, Lord Reid, I think Lord Burnett wants to ask a question.
Oh, yeah.
Sorry.
Yes, the example you've given, Mr. Southey, leaves aside the fact that this whole thing has to be linked to a risk to a particular child or children, and the matter is investigated fully. It's not just a question of somebody ringing up and raising a concern and then bang, it's all done and dusted. It seems to me a little unreal, the example you were giving.
Well, my lord, we all know how, to use an example, and I hope this isn't unrealistic, but there's a second point I want to make in response to this question. We all know how neighbour disputes can get exceptionally nasty. If somebody lives next door to you, and you're an offender, and they have children, it doesn't take a huge amount sort of imagination in our submission to imagine the situation where that person, because they don't like you, essentially, then make an application because they want to find out everything they can. want to know if there are any concerns. Now, the problem with the investigation submission, or the reason why it's then important to consult, is not just because the subject may be able to say, well, I have a really bad neighbour dispute. This is what's motivating it. It's also because, of course, the individual, given that the focus is on risk, may say, look, I understand why you're concerned. If my neighbour is unhappy with it, I would rather move than have disclosure, because by moving I can keep my privacy. And that may address risk. So there are a number of ways of potentially sort of in which the individual. I've focused on one area in which the individual may provide assurances, which is that the individual may be able to say this was a malicious application, but it's not far from the only way. The individual may be able to say there are other ways in which I can address risk. And the most obvious is by moving away. And from the individual's point of view, that may be a more attractive option. So that's why. But the final point I should make is that I've tried to emphasise, and I would wish to repeat, I think, about that although I accept that one reason why, which is sort of partially addressed in the policy, consultation is important, is because the individual may have something of importance to say. It's also important in terms of recognising that the importance of what's in issue, and that's the Osborne point. And as I say here, the reference to Osborne, I suspect, is fairly well known, not least because Lord Reid is on the panel. The reference to Osborne is at volume 4, tab 46, electronic 2515 is the relevant passages starting at paragraph 67. But that makes it clear, and that we submit that links back to the approach taken in the Article 8 case law. That makes it clear that consultation is not simply about ensuring that a decision maker is fully informed. Consultation is also about ensuring that the individual has a process that reflects the importance of what's in issue from their point of view. And just picking up, I think Lord Reid uses like, one needs to recognise here that this policy doesn't simply apply to people who have recently offended. It applies to people who may not have offended for a very long time and objectively have rehabilitated. I mean, they may have rehabilitated to the extent, for example, they're no longer on the sex offender register, and my lords will be aware of the fact that there is a scheme to come off the sex offenders register, as we point to. And if you look at the facts of this case, there is a lengthy period of non-offending. My lords, looking at the clock on my computer, I think it's 11:43 on my computer. I think that probably, subject to anything those behind me have to say, deals with all I want to say about the rights involved, because I'm conscious of the fact I need to spend some time on the approach to policy. So this probably is without committing myself that there's nothing I want to come back on once I've been told by those behind me that I've missed all sorts of critical points.
Don't worry, if you think of anything, you can return to it when we resume.
Yes.
If it's a convenient moment, then we'll adjourn simply for 5 minutes, and then.
Thank you.
Thank you very much.
Thank you, my lord.
Yes, Mr. Southey.
My lord, inevitably those behind me had some brilliant ideas. So there is one thing that I think I need to come back, and it's in response really to the point that my lord made, essentially, about the sort of balance between someone who's got a previous conviction and the police. And the one thing I think that I wanted to draw attention to was that, and I haven't been through the sort of large number of cases about this, it would have taken me all of today, but the only case that either party has identified which might be said to result in a conclusion that there was no need to consult is the R case in this court, which is at volume 5, tab 48, page 254, and it's referred to by my learned friend. I'm not going to take you to it, but at paragraph 66, the court rejected essentially the submissions that there was a lack of procedural fairness, but it did so for reasons given by the lower courts, and they were referred to at paragraph 16 of the court's judgment. And paragraph 16 made the point that the reason in that case why there was no unfairness is that there'd been a previous opportunity for the individual to make representations. Those representations had been rejected, and there was no reason to believe anything had changed effectively. And so it wasn't that there wasn't a requirement to involve the individual, it was essentially that it had been met. And so we submit that's not an example of effectively there being a conclusion there was no need to involve the individual. And that is the only that's the high point of my learned friend's case in relation to this. There are, in all the authorities that either party has been able to identify, it has generally been found there's a need to involve the individual. And so just to sort of answer really the point that perhaps consultation with people with previous convictions might be a sort of a different sort of category.
Sorry, could you give us the reference again, please? I think you said 254.
Sorry, it's a 2574, my lord. Sorry, I may have missed a 7 out of that if I did.
Thank you.
I wasn't meaning to suggest, Mr. Suddy, that the fact that somebody had previous convictions meant that there was no that consultation might not be appropriate. What I was suggesting rather was that the fact that the context is the investigation by the police of suspected criminal behaviour is something that has to be borne in mind in deciding what procedural obligations are appropriate.
Well, my lord, just to put that clear, the basis of the application is not necessarily that there has been criminal behaviour in relation to the specific applicant or the specific child. It's that there is a risk in the future. So that's the basis of the application. So if you had a situation, for example, where you've got previous convictions, the police's view was you continued to pose a risk, and they were concerned that you were becoming that you were getting access essentially to a child which might lead to risk, that under the policy would be a reason for disclosure. It wouldn't have to be established that you'd committed offences in relation to that child. So it's not, that's why I was perhaps going broader and looking at the cases about consultation with the police. This isn't simply a situation where the individual comes in and says, I think there's been offending against my child, I want to do something about it. It is a policy that is intended to apply and is directed at managing future risk, essentially. So there may well not have been any historic offending in relation to this child.
No, quite. But there needn't necessarily have been already a committed crime. But the purpose of this is the prevention of crime, is it not?
Yes. Yes. No, I don't just absolutely agree, except that. But that's why. I mean, to state the obvious, it's a situation where there is a significant public interest potentially in disclosure, and I accept that. But there is also a significant interest of the individual that needs to be balanced against it, and there may be ways of managing that risk as well that involve steps other than disclosure, and that's recognised in the policy. Well, can I go then to the the approach to policy. In our submission, policy, it's important to look at, to sort of consider how policies such as that in issue are intended to operate. The policy in question in this case is applied to a well-established common law power, but a common law power which is perhaps not well defined. And if because of that lack of definition, there clearly would be, there are potential issues that arise, for example, under Article 8, if it's used without guidance. The reason why there are issues is that because it's not clearly defined, there are clearly risks of unlawful decisions being taken if guidance is not issued. Guidance also, we submit, is important because it allows for good practice and understanding of legal duties to be shared. And there are examples, albeit perhaps not in the common law context, in the context of statutory schemes, of recent Supreme Court authority, where this court has recognised the importance of guidance, essentially, as filling gaps and providing greater clarity to a system that lacked clarity. And come back to the probably come back to these authorities depending on time. But to give two examples, Core Tab 6, electronic page 994, the case of Bibby, the immigration rule essentially provided for an exception in exceptional circumstances. The immigration rule that was challenged, I should say, provided for an exception in exceptional circumstances, and clearly immigration rules can also be departed from. One can exercise discretion outside the rules. And so it was guidance that the this court held was required at paragraph 55 to address the problem that without guidance there would be a significant number of cases, besides the word significant, come back to that, significant number of cases where there would be a breach of Article 8. Christian Institute case, which we've already been to, which is again for the note, Core Tab 2, page 827. This time, paragraph 100, dealing with proportionality, noted essentially that there was a problem with the Act, in that the Act didn't, it's on its face, necessarily provide a fair balance. But the solution essentially was for guidance to ensure that decision makers exercise their powers in a proportionate manner. And that's the critical point, is that guidance is important because it fills in gaps and it ensures essentially that good practice is learnt and legal obligations are complied with. The second, and I should say that in this particular context, won't take you to it, but in AB, I've already indicated the first authority dealing with this sort of issue, page 1207. Lord Wolfe again noted the need for policy essentially to safeguard against arbitrary decisions. Now, there's a second reason why policy is important and is again relevant to how one assess policy. This is, as already indicated, a national scheme. It requires police forces to work together. But if they're going to work together, that means that there needs to be common standards, common policies, common procedures. And that means there needs to be clarity to ensure consistency, essentially, and to ensure that the procedure that's been adopted it works essentially. And that's why the policy itself emphasizes the importance of compliance. Now, that's the context. And moving on from that, essentially, it's clear in our submission that there has been a considerable litigation, essentially, about how one assesses the legality of policy. And a useful, if not, we would submit entirely necessarily correct summary of the position is possibly found in TABAC, which is a decision of the Court of Appeal. It's at volume 5, tab 52, page 26, electronic page 2655. It's a judgment of Lord Justice Richards. Looks essentially at, interestingly, in one sense, at policies regarding the management of offenders. And Lord Justice Richards, at paragraph 46, identified 3 potential grounds for challenging policy. One, if the policy would lead to unlawful acts if followed, or if it permits or encourages such acts.
Sorry, the page again, please.
Sorry, 2655.
Thank you.
That is, the origin of that principle is said to be Gillick, and I'll come to Gillick in a moment. The second, which is, and the origin of this is said to be Munjaz, is a case where there is a significant risk of treatment that breaches Article 3. And the third sort of basis for challenge was essentially said to be that identified in another decision of the Court of Appeal, the Refugee Legal Centre case. And the easiest summary of essentially what the Refugee Legal Centre case decided, according to Lord Richards, is probably, or Justice Richards rather, is probably at paragraph 48, next page. Where he, having halfway through the paragraph referred to the Refugee Legal Centre case, he said, I've explained how I read the decision in that case. It concentrates on whether the system established by the relevant policy is inherently unfair. It does not reject the test of unacceptable risk of unfairness, but effectively equates an unacceptable risk of unfairness with a risk of unfairness inherent in the system itself. Now, there are a couple of few points that we should make about that analysis, which is, in some senses, it's a helpful starting point, but not necessarily the end of the matter. Firstly, just in passing, looking at that last sentence of Lord Justice Richards, in our submission, that's important because there are submissions of my learned friend, indeed there are passages from judgments which refer to inherent unfairness. In fact, it is clear in our submission, as Lord Justice Richards is indicating, that the issue is whether there's an inherent risk. And we accept that the distinction is between a risk that arises from the policy and a risk that is essentially a risk of aberrant decisions. The second point, which is why we would submit there needs to be a degree of care about this sort of analysis, is that ultimately we would submit that there is no real reason why there should be a distinction essentially between the Article 3 cases and other cases. Ultimately, the question is, how does the court approach a policy where it's said the policy is said to result in a risk of illegality? In our submission, Article 3, obviously, a breach of Article 3 is obviously illegality, but it's not the only human right. It's not the only form of illegality. A link to that, although Lord Justice Richards talks about unfairness in relation to the Refugee Legal Centre case, what we submit is that the most recent cases demonstrate effectively that the unacceptable risk test is applied to illegality more generally. So dealing with those three areas, of those three topics, or three grounds rather, the first, as I say, was identified in Tabak as being essentially the result of or based on Gillick, or derived on Gillick. Gillick is in...
But Gillick isn't concerned. Well, you're about to take us to it, but when you do, perhaps you could point us to anything in it that supports a test based on risk.
Well, yes, my lord. Can I? What I was going to take you to, my lord, is if one goes to Gillick's in Core tab 3, page 880. Lord Bridge, who was in the majority, firstly indicated that the issue wasn't a Wednesbury challenge by letter F at page 880, but then sets out a test essentially which seems to be which echoes the language essentially that Lord Justice Richards used, although Lord Justice Richards didn't identify a particular passage. And he referred essentially then to the jurisdiction to correct a public, or rather to intervene essentially when a public document contained advice which was erroneous in law. Lord Templeman was in the majority, I mean, it was in the minority, but in our submission adopted an approach very similar to that, and this is where the first reference to risk arises. It's at H894. It's by letter E. And he, again, in a context where he rejects the issue being unreasonableness, he indicates that if the memorandum is defective by reason of mistake in law, and as a consequence, and if in consequence, a doctor making a decision in reliance on the views expressed in the memorandum may unlawfully interfere with the rights of the individual, then in my opinion, the DHS, which is responsible, is amenable to the remedies of judicial review. So Lord Templeman, in my submission, is recognising that there is a need to link a risk of unlawful outcomes.
But his decision isn't being based on an assessment of risk. Is it not based on his conclusion that there was a mistake of law in the guidance?
Well, two things I'd say about that were three things. Firstly, whether or not I'm right to say that Gillick is a helpful starting point, the tobacco approach, which is one of the reasons I drew attention to it, suggests that there may be other grounds. So,
if you look at what he's in the paragraph you've taken us to, if you look at the second sentence, the memorandum asserts that the doctor is entitled by himself to decide whether an unmarried girl under the age of 16 should be provided with contraceptive facilities. In my opinion, the decision cannot lawfully be made without the consent of a parent. So that's a mistake of law. And as he goes on, if the memorandum is defective by reason of a mistake of law, and in consequence that a doctor making a decision in reliance on the memorandum may unlawfully interfere with the rights of a parent, then the DHSS is amenable to judicial review.
Well,
he's not concerned with And he uses the word may, but his decision isn't based on an assessment of a level of risk. His decision is based on the fact that the memorandum is giving advice which is wrong in law.
Well, my lord, all I'm suggesting is that although, in one sense, well, no, although we would also argue that the case law has developed, it's not. The critical issue perhaps is whether or not it's inconsistent with Gillick, and Gillick, and I should just draw attention, Lord Scarman is page 869, electronic by letter F. He uses the language of encourage, essentially, unlawful conduct. He says permits or encourages unlawful conduct. All I'm saying is that there's nothing, certainly there's nothing that is inconsistent with the subsequent development, which quite clearly does focus on risk.
Is there anything wrong with the way Lord Scarman puts it there? In that sentence you've just taken us to, on page 869, electronic, letter F.
It depends what there's nothing. There's nothing. If it's regarded as non-exclusive, then no. But if that is the only basis, then yes, because the case law in our submission has properly developed to recognise, partly influenced by concerns about in accordance with the law, that guidance has to effectively eliminate risk.
Well, you say it's developed. Has anybody ever departed from this decision of the House of Lords?
No, but that does, because there's nothing here that says one doesn't need to depart from it in my submission, because there's nothing here that says these are the only circumstances in which a policy can be challenged.
Well, it's talking about a challenge on the basis that essentially the Secretary of State has acted unreasonably.
Yes.
I mean, plainly, there might be other grounds of challenge.
Yes.
Now, what's the ground of challenge in the present case?
Well,
I mean, I know you say a risk of a breach of Article 8 is sufficient to entitle you to a remedy, but I'm wondering on what ground do you say that?
Well, we say that for two reasons essentially. Can I say firstly, just to clarify one thing, because my lord used the language of risk. When I started on this topic, I made it clear, and this is important in my submission, that the issue is whether the risk is inherent in the policy. So one can always have a situation where someone, for example, adopts an unreasonable reading of a policy and acts unlawfully, and that's not what we're concerned with. But the reason I say that is for two reasons. Firstly, because the prohibition in the Human Rights Act essentially on a breach of rights is absolute, if a decision maker acts in a way that it is at risk of causing a breach, then they're breaching their obligations. There's a parallel almost with the sort of situation that arises in relation to, for example, Article 3 removals, where it's unlawful essentially for the state to run a real risk of removal. And I use that language deliberately because that's the language that has been used in some of the authorities. Is there a real risk essentially?
That's a different situation. I mean, the test of real risk has been used by the Strasbourg Court specifically in relation to Article 3 and yes, Article 3 issues in the context of deportation. We're not in that area here.
No, we're not. But in the context of policy, domestic courts recently have used that language of real risk. And in my submission,
are they right? I mean, you're in the Supreme Court. The question. And I'm not really kind of interested in how often the Court of Appeal or the High Court may have done this. We're looking at a House of Lords case here, and the question is, has the law moved on, and if it has, on what basis? Lord Sales.
Yes, I was waiting for Lord Sales, my lord, before.
I'm so sorry. I hadn't, in fact, meant to cut across my Lord Reed, but I wanted to ask you, if I may, two questions. The first is, if you look at page 868 at E, this is in the judgment of Lord Scarman.
Yeah.
He says the first question in the appeal is simply, what is the true meaning of this text? Now that seems to be at odds with what you're telling us is the relevant approach, which is to ask, is there a range of meanings that could be attributed to a text such that a risk arises? That's my first question. What do you say about that?
Well, can I also answer Lord Reed's question and then come and then?
Of course, yes. Sorry,
yeah.
I didn't mean to cut across.
No. It's difficult. My lord, can I? But it does then link into this issue of well, the reason I was using the language of real risk was that there is an analogy that can be drawn in the sense that when one is looking at policy, a policy maker is looking essentially forward, and they're looking at what the consequences essentially of their policy will be. They're seeking to predict, and that's why an analogy can be drawn with the removals cases, because again, what you're seeking to do is predict, and you're looking at what is what guidance you need to put in place. The second reason, though, we say that unacceptable risk is the correct approach, certainly in the human rights context, is because of the point that was made in the Christian Institute case, which I took the court to, about in accordance with the law, which is that policy in practice in a context like this is one of the ways in which the duty to essentially ensure that proportionality is assessed is met. And so if you have a policy that results in a clear risk of a breach, one is not essentially meeting the approach identified in a series of cases in this court about the need to have sufficiently clear guidance to ensure in accordance with the law.
Now, Mr. Southey, if you look at the test that Lord Scarman is adopting at letter F on page 9, whether the guidance permits or encourages unlawful conduct. Now, that test would have been met in the Christian Institute case because well, in fact, it was legislation in that case, but devolved legislation, and so it wasn't like an act of parliament. The provisions permitted or encouraged unlawful conduct. It certainly permitted unlawful conduct by, well, indeed, they encouraged them by encouraging the sharing of confidential information without proper disclosure to the subject of the information. So Lord Scarman's test would have been met. Now, I'm wondering, is there anything wrong with that test in the context of the present case? And is your case not that the guidance in question permits or encourages unlawful conduct, unlawful in that it breaches either common law duties of fairness or Article 8 procedural duties?
Well, my lord, can I, in one sense, we would say no. We would certainly say that the permit test is potentially met here, in the sense that the guidance, as read, doesn't unlike the MAPA guidance, suggests that there is a norm for consultation. It leads a decision maker to believe that effectively they have a broad discretion as to whether to consult. So, just to be clear, I'm not suggesting that necessarily the Lord Scarman test is not met in this case. However, what I would say is that if one looks at Bibby or the Christian Institute case, or indeed the Northern Ireland Human Rights Commission case, all of those cases in our submission, perhaps looking at the issue of whether or not policy permits, then focus on whether there is a real risk, essentially, or whether there's an acceptable.
Well, in the Northern Irish case, Lord Mance puts it a good deal higher than real risk. He talks about being bound to result in a breach, or a breach being the inevitable result.
Well, I think he uses different language at different points. In to be fair, but can I just give him my Lord's question about Christian Institute, and I haven't forgotten Lord Sales's question either. But given the question, can I just draw attention to the point that I'm making about Christian Institute? Christian Institute succeeded essentially on two grounds. One was the in accordance with the law, but in relation to proportionality in particular, and the guidance, the approach was that the legislation, answering my Lord's point about that, pointed away from proportionality, but it was accepted that you could in fact achieve proportionality with appropriate guidance. The problem was the guidance wasn't precise enough, essentially, and didn't deal with the right issues. So that is a recognition in my submission that a lack of precision, essentially, in the guidance can be unlawful as a matter of domestic law, because of the fact it may result in decisions that breach the Human Rights Act, my Lord. And that's why I was referring to the Christian Institute case. My Lord, can I answer my Lord Sales's question now? And I apologise for having not answered that quicker. Our submission is this: is that in the Gillick case, the relevant language was essentially pretty clear. If ultimately the question is, and we submit, not just at Court of Appeal level, but at Supreme Court level, that this is the question. The question is whether or not there is an unacceptable risk of illegality. Then when one looks at that, one has to look at vagueness in the language. And if the language can be read understandably and legitimately in more than one way, one has to take account of that fact, because that inherently gives rise to a risk. This is
yes, but forgive me for interrupting. Yeah. I think what I was putting to you is, given that Lord Scarman puts the point in the way he does at page 868 at E, isn't that indicative of the fact that it's not a risk-based approach? You just said if the test is unacceptable risk, you have to look at possible meanings of the text. And I think what I'm putting to you is, since Lord Scarman says it's not a question of looking at possible meanings of the text, but at its true meaning, isn't that indicative of the fact that it's not a risk-based approach?
Well, two things. Firstly, if one then looks at the test that's been put to me by Lord Reid, which is permits in our submission does involve some consideration of risk, because it involves looking at what effectively are the potential outcomes of the policy. Even if I'm wrong about that, in my submission, given that the absolute nature of the obligation under the Human Rights Act and the case law that has subsequently developed has been based on the Human Rights Act, the Human Rights Act, in my submission, potentially requires a different approach. Yes, if I'm wrong about that.
And could I ask my second question then, which relates to the reliance you seem now to be placing on the in accordance with the law requirement in Article 8.
Yes.
And you seem to be making an argument that that shows that policies have to eliminate risks or a degree of risk. But from my recollection, we haven't looked at the in accordance with the law cases here, but the basic idea of in accordance with the law is that it gives a reasonable indication as to how a legal test should be applied. It doesn't eliminate all risk, and that isn't the standard which is applied under the in accordance with the law requirement in Article 8, is it?
Well, my lord, can I be clear? And I'm probably to blame for this, but firstly, we've not suggested that you need to eliminate all risk, because there's always the risk of aberrant decisions, and one can't eliminate all risk. It's a real risk, and it's a real risk of illegality inherent in the policy. And that's the second point. So that, but the reason we say that's the correct approach essentially is that if one looks, for example, at Christian Institute, the approach essentially to in accordance with the law was that there was a requirement to enable proportionality to be assessed. If one looks at P, that was the approach, and that then in our submission it is consistent essentially with I think it's Bibby, which does talk about risk being, and I need the reference. Sorry, yes, it talks about effectively guidance needing to be recast, and the reference for this is, I think it's core tab 6, page 994, paragraph 54 and 55. That page may be slightly wrong because I think my notes refer to where I was first going to go to in the judgment, but it'll be something at 994 it'll be something slightly late after 994. 994 is where the issue was described. But it's paragraph 54 and 55 where the criticism essentially was that the guidance resulted in, and I'm looking at my notes, but I hope this is an accurate quote. Look, the issue was whether or not there was, or the finding was that there were likely to be a significant number of cases that do not strike a fair balance, and that was held to require the guidance to be recast.
And what do you say then happens where Article 8 doesn't apply? I thought that we were having a debate about common law standards in relation to the acceptability of policy guidance, well, which will apply whether or not Article 8 is in issue.
Well, my lord, our basic point, but whether or not we're right or wrong about this, that there may be set then issues that arise under Article 8 if we're wrong. But our basic point about this is that why, in one sense, domestically does Article 8 require that approach? It does essentially because the Human Rights Act contains a complete prohibition on breaches of Article 8, and so as a matter of domestic law, it cannot be correct for a decision maker to run an unacceptable risk of illegality. Now, if that's the correct approach, then there's no reason in our submission why unacceptable risk shouldn't apply to other principles of domestic law, which ultimately the Human Rights Act is a provision of domestic law, and it cannot be any more acceptable for a decision maker to run an unacceptable risk.
Yes, thank you very much.
Well, Lord, I'm very conscious of the time, and I'm conscious of the fact I think I'm right up against my time deadline. Can I just make two very quick final points, and they're going to have to refer to the authorities. I've sort of mentioned recently Bibby, and I've mentioned Christian Institute. But one shouldn't lose sight, again, at this level, of the fact that a majority in Munjaz quite clearly, in my submission, applied essentially the significant risk test when looking at policy. Lord Bingham, at page 2435, tab 44, volume 4, paragraph 29, considered the issue of whether there was a significant risk of ill treatment. Lord Hope, paragraph 80, adopted the same approach. And Lord Scott, paragraph 101, agreed with both of those judgments. And so, although there has been a recent focus on this, in our submission, one can trace that back to Munjaz, and there's no real I accept there's no real analysis in Munjaz of what the basis of that principle was, but in our submission it has to be the point I made previously, which is that the Human Rights Act is absolute, and as a result there is a need to avoid risk of that. The second point I wanted to make very briefly was to just draw attention to an authority cited by my learned friend. I'm just looking for the reference to it, which is the Bayer, recent decision of the Court of Appeal in Bayer. And that is important because in my submission, I'm struggling to find the reference to it. I may need to come back to the reference, but the reason that's important in my submission is because it makes the point that it draws a distinction essentially between the fact that there is often no duty to issue a policy, but if you do issue a policy, because it will be essentially turned to and relied upon, you need to get it right. Sorry, the Bayer judgment is at tab 4, the core volume, page 954. I think it may actually be 955, the relevant passage, particularly paragraphs 207, which is where Lord Justice Underhill looks at this issue of cases where there's been a sort of an approach looking at risk, draws a distinction essentially between cases where policies had undertaken the responsibility. And Lady Justice Rose is para 214 on a similar line, and that's at the end of it. The critical point is, if you don't have this policy, a decision maker such as a police force is going to have to seek its own advice, potentially seek legal advice, develop some policy. When it's handed a policy, in our submission, the policy then has to be clear and has to eliminate a real risk that people following or purporting to follow the policy will essentially act unlawfully.
Yes, Mr. Sully, since we're looking at the Bayer case, could I invite your attention to paragraph 200 at page 954? Because that is Lord Justice Underhill, and I think he's speaking for the court here, in effect, analysing what was said by Lord Scarman in the relevant passage in Gillick. And he makes the point that in context, permit, as used there, means something like sanction, i.e. positively approve. And that, again, if I may say so, just reading it there, seems to be at odds with your interpretation of permit in your submissions as giving rise to a risk-based analysis, i.e. permit means you can do anything at all, whereas here the emphasis on permit is positively encouraging or approving some course of action which is in fact unlawful.
Well,
I wonder what your reaction was to that.
well, in my submission, that needs to be read in context, and 2 points I'd specifically draw attention to. If one goes to 202, just sets out the factual context, which is that the particular policy simply didn't deal effectively with the the issue, but then more importantly, in some senses, para 207, which is where Lord Justice Underhill deals with the issue of Tabac and the Refugee Legal Centre. And he deals with them on the basis that, unlike the Bayer case, where effectively the policymaker had left the decision maker, the decision in question, the decision that was challenged entirely to the actual decision maker, he explained those as cases where essentially what had happened was that the policymaker in Refugee Legal Centre and Tabac had taken responsibility for prescribing a policy, and in those circumstances, he indicates that the policy had to be essentially one that eliminated that reduced risk other than inherent risks. Sorry, that only resulted in inherent risks. And in my submission, that what that's indicating essentially was that Bayer was concerned with a different situation, but Lord Justice Underhill is certainly not suggesting that where you have a situation, which is what we have here, of a decision maker who has taken on responsibility for essentially prescribing a policy, they don't have to essentially then make sure that the policy is one that eliminates inherent risk, or brings it down to a satisfactory level. Because the problem here, and just to finish on this, the problem here, which is not the situation in Bayer, is you have decision makers who are told this is effectively good practice, you have to follow this if you're part of the scheme, and are not told in clear terms the norm should be consultation.
Yes, thank you.
Lords, I'm very conscious of the fact that hopefully unusually I've overrun, but I hope there's reason for that. There are obviously other things I could go to, but that's set out in writing. But I hope I've covered everything I need to cover.
Thank you very much, Mr. Sadi.
Thank you.
I will turn then to Mr. Moffat, Queen's Counsel, on behalf of the Secretary of State.
Thank you very much, my Lord. My Lord, can I just first of all check that the court can hear me?
Yes, perfectly.
I'm very grateful. Well, what I propose to do, if it's convenient to the court, is to take my submissions in the following order and deal with 6 main themes. First of all, I want to make some very brief submissions on the facts. Secondly, I want to set out for the court what is in essence our headline response to the claim on the facts. Thirdly, I want to look at the correct approach to the common law challenge, which has been the focus of Mr. Southey's most recent submissions. Fourthly, to look at the correct approach to the Article 8 element of the challenge, and then touch very briefly on the requirements of fairness, and finally deal with the application of the law to the fact. So I hope that's a convenient course to take. Can I start then with just 3 very brief points on the facts, if I may? The first point to make is a rather obvious point, I suspect, is that the disclosures that are being made in these cases are being made by police forces. And they are being made by police forces in the exercise of their own powers. The guidance doesn't and couldn't purport to create some new power for the police to disclose information. The second point flows from that. The police are independent public authorities. They exercise their own functions, and when they do so, they are subject to freestanding public law duties. It is the police who are subject to the common law duty to act fairly. It is the police who are subject to the Section 6 duty to act compatibly with convention rights. And those duties apply regardless of the guidance, and nothing in the guidance purports to or could displace them. And the third point is, because the focus of the challenge has always been on the guidance and the wording of the guidance, there's actually no evidence, and never has been any evidence before the courts, to suggest that when they exercise these powers, the police don't generally act in accordance with their own duties. The appellant has never criticised the police's understanding or compliance with their own freestanding public law duties. And there is no evidence before the court that the police don't properly understand those duties. There's no evidence before the court that the police haven't taken appropriate steps to make sure that they comply with them. For example, there's no evidence that decisions are taken by anything other than senior officers who've been appropriately trained. The court will have seen that the scheme was subject to a careful piloting and evaluation, independent evaluation exercise before the guidance was issued. That pilot scheme didn't raise any issues about fairness. And insofar as the Secretary of State is aware, apart from the two challenges that have been brought by this appellant, no concerns about procedural fairness have been raised since the guidance came into effect. And there's certainly no evidence that there's ever been procedural fairness in any particular case. Now, those 3 points are relevant when I come on to my second main theme, which is the Secretary of State's headline response to this particular claim on the facts. The broad thrust of the appellant's case, as we've just been hearing, is that the guidance is unlawful because there is it's put in various ways. There's a significant risk, there's a real risk that the police will act in a way that is procedurally unfair. Now, as I understand the way Mr. Southey puts his case, he is not saying that there is a duty to eliminate risk. So on the test that he sets himself, Mr. Southey, in order to succeed, has to show that there is a significant risk that the police will act unfairly. But on the evidence, there's simply no case to be made on that point. And I said I'm taking it briefly at the moment because this is really our headline response on the facts, but I'll take it in 2 stages. Firstly, there is nothing in the guidance itself which creates a risk that the police will act unfairly. As the court has seen at paragraph 5.5.4 of the guidance, it expressly recommends that the police consider seeking representations from the subject. There is nothing anywhere in the guidance which suggests or recommends that the police should not seek recommendations. It leaves it as a matter for the police to consider on the facts of each individual case as they arise. So far from creating some sort of risk that the police will act unfairly, in fact, on its own terms, the guidance positively enables the police to act unfairly and to discharge their duties.
Mr. Muffet, I don't know if you would like to deal with this just now or at a later stage, but speaking for myself, I'd find it helpful to understand if you accept Mr. Southey's account of the relationship between this guidance and the MAPA guidance in a situation where the subject is covered by MAPA arrangements.
Well, Lord, I could deal with that later, but perhaps I could give you the short answer now, if I may. I mean, it is true that in certain parts the guidance does not expressly refer decision makers back to the MAPA guidance in the particular section in in section 10 of the mapper guidance that the court was shown about in fairness. But the Lordship is absolutely right that in cases such as the appellant, if a request for disclosure was made, that request would be considered by the mapper authority. So it would be considered by an authority that is obviously, one would assume, well used to applying the mapper guidance and is familiar with it. There is a further point, and I don't need to take the court to it now. If I could just give you the reference, if I may. It's at electronic page 361, and it's paragraph 2.6 of the guidance itself. And that makes clear that the disclosure scheme, the words it uses, builds on existing procedures. And it goes on to say in a bullet point that the mapper guidance explains how responsible authorities should approach the issue of disclosure. So in that context, it is directing responsible authorities, who are the mapper authority, to the mapper guidance that the court was shown.
Now
So although,
sorry,
I beg your pardon.
Well, I was going to raise with you a point that's made in that paragraph, which is that mapper guidance is statutory.
Yes.
And by virtue of statute, it has to be applied when you're dealing with a person such as the appellant, is it not?
Well, it's slightly different. The statutory part of the mapper guidance applies to a specific statutory function of disclosure under section 327A of the Criminal Justice Act 2003. It's not necessarily the case that a disclosure made under the scheme would fall within the scope of that power. The scheme goes wider than that power, my lord, because the statutory power only relates to very specific offences.
So at the end of the day, what I'm wondering really is if the appellant were the subject of consideration for disclosure of this sort of information, would the mapper body look only at the policy which we've the CSOD policy, or would it also consider the mapper?
Well, that's why I was referring to paragraph 2.6 of the guidance itself at page 361, because what it says there is that the mapper guidance explains how responsible authorities should approach the issue of disclosure. It's not put in narrow terms and said it explains how they should approach the issue of disclosure, brackets, only in the specific circumstances to which the statute applies. It's a general pointer towards the mapper guidance for mapper authorities when they're faced with these decisions. So, I mean, obviously, it was very difficult to predict, and this is really one of the core problems with the way the appellant puts the case. It's very difficult to predict how an individual authority would act and react in an individual case, but certainly insofar as the guidance is concerned, it's giving them that steer towards the mapper guidance. And it's not, as I think Mr. Southey sought to portray it, seeking to portray the different functions and the different types of guidance as somehow in silos, which have no cross-application. So I don't know if that answers my lord's question.
Well, it is helpful. Can I also raise this with you? The mapper guidance is issued under section 325, subsection 8 of the 2003 Criminal Justice Act. Now, in terms of that provision, I'll just bring it up. Yes, the Secretary of State may issue guidance to responsible authorities, which is a term of art, on the discharge of the functions conferred by this section, that's 325, and sections 326 and 327A. Now, 327A is the provision that deals with disclosure of information about convictions to members of the public in the case of individuals who are of child sex offenders who are managed by MAPA arrangements. So, and are we to? Is it your position, or it may not be, that the MAPA guidance that we have before us is guidance issued for the purposes of section 327A?
Yes, that's the statutory basis for the MAPA guidance.
So in that case, is there not a yeah, so all right, thank you very much.
Well, it may help, it may confuse things if I put it this way. There's the power under section 327A, or it's a duty to consider disclosure that section 327A imposes in very specific circumstances in relation to very specific offences and information about very specific offences. So it's quite narrowly drafted in some senses. And the relevant part of the MAPA guidance, insofar as it is statutory, relates to that particular function under section 327A of the 2003 Act.
And there is a statutory duty on the part of the MAPA authorities to have regard to that guidance under subsection 8A of section 67.
Yes. But of course, I think this may be the point your lordship is making. Of course, that's duty only applies when they are discharging the obligations that section imposes upon them. It's not a statutory duty to have regard to the MAPA guidance more widely when they're exercising other functions, such as, for example, functions under this scheme that the court's concerned with today. But as I pointed out, this scheme cross-refers to the MAPA guidance. And just because the MAPA guidance, insofar as it's statutory, relates to a particular function, doesn't mean that the substance of it is irrelevant when authorities are discharging similar functions elsewhere. So I think it's been a very long answer to your lordship's question, but I think the short answer is that there's nothing in the guidance which suggests that somehow there are silos here with MAPA in one silo and the guidance in other silos. In fact, quite the contrary, the guidance itself expressly cross-refers to the MAPA guidance. And it says that the MAPA guidance explains how responsible authorities should approach the issue of disclosure. I'm sorry, Lord Briggs.
Mr. Moffat goes a little bit further at paragraph 5.6.13 on page 372, does it not?
Yeah.
Because there it seems to separate subjects, i.e. subjects of a disclosure application under the scheme, into two categories. Those who, quotes, meet the MAPA criteria, in which case it will be dealt with at a multidisciplinary, the decision whether to disclose under the scheme will be dealt with at a MAPA compliant multidisciplinary meeting. And those subjects who I suppose don't meet the MAPA criteria, in which case it'll be an ordinary safeguarding children procedure.
Your lordship, sorry, beg your pardon.
No, go on. I mean, it just strikes me that it's not just a question of making a sort of vague cross-reference to the MAPA guidance, but a rather more structured streaming of potential subjects into two classes who would be, at least procedurally, differently dealt with so far as the decision-making was concerned.
Your lordship is absolutely right, and I'm sorry, perhaps I didn't make that point clear, but that's rather the premise for the responsible authority is a term of art that's used in the legislation to refer to the MAPA authority.
Yeah.
And the way that the scheme works, as my lordship has just pointed out, is that it channels individual subjects into two streams. And where they are subject to MAPA arrangements already, on an ongoing basis, the decision is made by the mapper authority, the responsible authority. And of course, it's that responsible authority that, as a matter of statute, as my Lord Reed was pointing out, the mapper guidance is directed. So your Lord's absolutely right. There is a structure there which channels certain types of individual, including this appellant, into consideration by the mapper body, by the mapper authority.
But are the police one of the relevant multi-agencies within MAPPA?
Yes,
I assume they were.
Yes, they are. I say that I'll no doubt be given a sharp electronic kick under the table if I'm wrong about that. The mapper authorities are, from memory, the police, probation, and prisons.
Yes.
I'm trying to find it in the mapper guidance.
No, I mean, if you tell me it is, unless somebody pulls your leg and tells you you're wrong, I'm quite happy to take it without the details.
I might come back on that if I may, just to confirm. I don't want to. That's certainly my recollection, but I will come back and confirm if I may, my lord.
Thank you.
And I mean, it's unfortunate we don't have the 2003 Act in the bundle, but Section 327A imposes a specific duty on the responsible authority to consider whether to disclose information about the relevant previous conviction, which is a term of art defined essentially to mean convictions of child sex offences.
Yes.
Of any child sex offender managed by it to any member of the public. And in carrying out that duty, it's bound to comply with the MAPPA guidance, or it's bound to have regard to the MAPPA guidance, which is issued under Section 325 by the Secretary of State. So one would have thought that if the MAPPA authority were considering whether to disclose such information about the appellant, then it would be required by statute to have regard to the MAPPA guidance.
Well, in certain cases, I mean, I don't want to sort of drill into Section 327(7)(a) because what, as I said before, Section 327(a), and your lordships pointed this out, is quite focused. It's talking about certain types of convictions for certain types of offences. Yeah. So it might be possible to envisage a scenario where the relevant disclosure did not involve disclosing information about the relevant previous convictions. It's quite hard to envisage what that might be, but I certainly wouldn't want to rule it out. And I certainly wouldn't want to claim that in the case of the appellant, the only route, or rather that it's inevitable that the route would be through Section 327(a). And of course, I would accept there may well be other types of individual who would be affected by the scheme who wouldn't come within the Section 327(a) types of offences. So I accept the point your lordship makes, but I think probably it's important just to qualify it a little bit.
Yeah.
My lord, just while I'm there, Mr. Knight has very kindly kicked me under the table, thankfully to say I'm right, that it's the police, probation and prison. It's paragraph 1.7 of the MAPPA guidance, and if you'll note, that's page 446 in the introduction to the MAPPA guidance.
Thank you.
So, Lord, unless there was anything else on Section 327(a), can I just very quickly before 1 o'clock finish off this second opening point, as it were? I made the point that the guidance in itself can't be said to create a risk of the police acting unfairly. And the second point is, as I've already stressed, there's absolutely no evidence that apart from the guidance, putting the guidance to one side, there is a significant risk that the police will act unfairly at all. So actually on the evidence, even if the court were to adopt the test that Mr. Southey argues for, there's no basis for concluding that that test is met. There's actually no evidence before the court that there's a significant risk, whatever that means, of the police acting unfairly. What the appellant is essentially inviting the court to do and this rather picks up on a point that I think my Lord Sales was making in his questions, is he's inviting the court to speculate as to how this might be implemented in practice. I see it's 1 o'clock, if that's a convenient point.
Yes, thank you very much, Mr. Muffet. We'll adjourn then until 2 o'clock.